Matthew, I'd like your perspective on something. This is a difficult issue. The sense that what we know and what the jury was not presented with was kind of the backstory on the victims in this case about about Mr. Rosenbaum and Mr. Huber's past, criminal past, controversial past. They were painted in the media as really bad people, and arguably so based on some of the things that they were implicated with in the past. The jury was not presented with that information. Do you think that's relevant to that discussion? Because remember, it wasn't presented in trial since Kyle Rittenhouse didn't know who these guys were. You know, if the jury had any inkling of who these victims were, they might have said, well, they deserve to die. And that's clearly not what needed to happen. And we know that Kyle Rittenhouse at the time, he didn't know anything about these individuals, so it doesn't really go into the self-defense argument. But now that the trial has concluded, that conversation is really coming up. What's your response to that?
Is it a relevant part of the discussion? I think it is. But when we're talking about self-defense, we're really assessing self-defense. We want to know about reasonableness and reasonableness as it applies in real time to this particular defendant. This particular defendant didn't know these things at that time and made a decision to pull the trigger without knowing those facts. And as such, the jury should decide his fate in the same fashion. And I think that that was a good move, right? Preserving a victim's character is sometimes really important. There are reasons why we have evidentiary codes around this kind of thing. It's because it protects a runaway jury. And so I thought that that was effective, especially when we're analyzing whether this is self-defense or not.